Okay, Shannon, you can put us on the record. Okay, first matter up this morning is Ann Arbor State Bank versus Indian Brook Trout Farm.
John, why don't
Mr. Elliott?
yes, Your Honor. Bruce Elliott for Ann Arbor State Bank, now known as Level 1 Bank, who's the successor in interest. This matter is a motion for entry of default judgment. It's made in connection with Mr. Polderman's motion for approval of final accounting and essentially to close out the receivership. I tried to schedule those at the same time because they essentially have the same effect of closing the case, hopefully, and winding up.
Mr. Elliott, let me stop you for a minute. I'm trying to figure out if there's anyone else present on this matter. Looks, John Polderman?
Good morning, Your Honor. John Polderman, court-appointed receiver.
Okay.
Can you spell that, please?
Polderman. Okay. And I don't see the individual defendant present. I don't have any opposition to your motions today, and nobody is appearing in opposition to them. I am going to grant both of your motions. Just a second, someone just walked into the courtroom. What's your name, sir?
Gary Morgan.
Oh, okay, just have a seat. Okay, no one's appeared, no one's filed an opposition. I'm granting your request. It looks like I've got a couple proposed orders here. First is a default judgment. And we will get that entered and back to you. And I'm assuming there is an order approving the final report. Let me see if I can find that. Yes, here it is. And I will sign that. And we'll make sure somebody gets these back to you. Anything else the court needs to address on this file today?
No, Your Honor.
Not that I'm aware of, Your Honor.
Very well, thank you.
Thank you.
Thank you, Your Honor.
Assume we can leave.
Yeah, go ahead, you're free to go. Peter, I signed both of these, but they need date stamps and judge stamps, I think, in a couple of spots. Next up is Airway Welding versus Rogers.
Good morning, Your Honor.
Counsel
Bruce
state-
Inocencio on behalf of the defendants, or excuse me,
Joseph Spiegel on behalf of Rick Rogers, and Paul Bernard is also present today.
All right, I read the motion, I read the response. Frankly, I'm not inclined to give any authority to the receiver to resolve disputes about the details of putting your settlement together. I would strongly encourage you to utilize him for that purpose, but I don't believe the court has authority to empower a receiver to act as a arbiter of disputes regarding the details of your settlement. If you're ultimately unable to reach agreement on these things, and I find that they are material, I guess you'll be back in front of here, one of you asking me to enforce the settlement agreement, the other asking for me to set aside the settlement agreement. But you're not at that point yet today. Gentlemen, you're gonna have to figure this out on your own.
Your
Agreed,
Honor, if I may please briefly, Rick Rogers is the only one who's performed on this principal settlement agreement. He's an officer, director, and shareholder. He's not receiving any information. We don't want to drag the court back into this matter on obtaining financial information, having his access to the business records of a company he's still an officer, director, and shareholder of. There is an order whereby Mr. Ponderman should be appointed as a receiver. And if the court would allow me to amend, if you will, the motion, we're more than willing to have the receiver appointed entirely, not just for resolving the settlement issue, because we can't abide by entering into any kind of term sheet where we're the only party who's performing. And my client still has an absolute right to be a part of the company. There is a preliminary injunction that is currently being violated. We didn't make a motion to show cause. We didn't take any action in that
Mr.
regard.
Spiegel, Mr. Spiegel. Let me
Yes.
stop you for a minute. After reading the motion in response, I thought I read that you did agree on who is going to be the receiver. Is there a proposed order appointing the receiver? I'm assuming it was stipulated to. There ought to be an order for that purpose.
I will submit one today, Your Honor.
Your Honor, may I respond to that?
What- Well, just a minute. I mean, once a receiver is appointed, doesn't the receiver then have access to and ability to address all of these issues regarding company documents?
Yes.
All right, go ahead, Mr. Inocencio.
Thank you, Your Honor. Your Honor, to begin, I don't understand how it's possible that defendant's counsel is saying that his client, Rick Rogers, is the only one that's performing here. Mr. Rogers has effectively retired from the business. He's not doing anything. My clients have continued to run the day-to-day operations of the business. The other claim that's been made here today, and also in the pleadings, is that we have not shared with him financial information. Your Honor, we were asked to provide 2 documents, and I contacted the client. He made arrangements to have those sent to me from the accountant within an hour or 2. I then forwarded those to Mr. Bernard because he has email, and I guess the other attorney involved in this case does have an email account but doesn't want it used. And we provided the password, and Mr. Bernard confirmed for me that those documents were received and that he was able to open them. I am unaware of any financial information that has been requested that we have not provided. So to come into this court today and make that claim is absolutely preposterous. It's unethical and lacks integrity. I know
First
this
of all,
court.
Mr.
I'm not finished.
Inocencio,
I'm not finished.
I sent you a letter
Hold
on
on.
September 15th,
Everybody-
and I specifically
everybody
asked for
stop.
documents. Stop lying to the court.
Mr. Spiegel, when I speak, you shut up. Is that clear? I've got a mute button and I plan to use it. When I speak, you stop speaking. I see Mr. Bernard is present. We need to make note of that for the record. Co-counsel for the defendant, is that correct, Mr. Bernard? All right.
That's correct, Your Honor.
All right, I just wanted to make sure our clerk had everybody's name down. So,
I had one other point, if I may, Your Honor, briefly.
go ahead.
Your Honor, we entered into an agreement to have a receiver appointed at a point in this case where our settlement discussions broke down. And the plan was going to be that the assets would be auctioned off. This cannot be refuted. If the court actually looks at Exhibit 2 to plaintiff's motion, let's pull that out for a second. It's very critical. This is the stipulation and order that was tendered to the court. And this court might not remember it being entered because the court was out for a couple of weeks due to a medical issue, I know. And we had Judge McBain sign this in the court's absence. But if the court looks at paragraph 6, which is found on page 3 of the stipulation, the court will read at the end that the receiver was going to undertake the duties as shall be set forth in a receivership and auction order. We have since resolved the case. There is no auction of assets. The whole point with this stipulation to have a receiver was because we agreed that the assets were going to be sold and that the matter would be headed to an auction through the guidance and supervision of a receiver. We have since entered into an agreement in principle where my client will continue to manage and operate the operations of these entities, and the defendants are being bought out. This stipulation and order no longer has any bearing. There's no need for a receiver at all. We're running the company day to day.
So where's the settlement agreement?
So the settlement agreement, we have written documents back and forth. I've been working on the actual draft of the settlement agreement, trying to figure out with the accountant on our side exactly where we need to come down on the allocation of the assets. What we have, Judge, is we have a total number that is going to be paid for the assets. The manner of the percentages that are going to be assigned to those assets from the total amount is calculated by our client's accountant. And we agreed that that would be appropriate. We have to do an allocation pursuant to the IRS rule that requires it. I don't recall the specific Internal Revenue Code section right now, but Steve Patch is working on that. As soon as we have those pieces of information, we can say, this is how much this asset is going to be sold for. So for example, let's say that the number is $2.2 million. And we agree that 40% of that amount should be allocated to Brit. Then we would know that the value of Brit LLC in the settlement is $880,000. We would then know, based on everyone's percentages, that my client would retain 46% of that. Mr. Rogers would retain, Rick Rogers would retain 46% of the 880, and each of his two sons would each retain 1 1/3%. The value of that would be paid to them. Until we have those kinks ironed out, there are too many moving pieces to put that into place. My understanding, Judge, is that I will have an agreement on that sometime later this week. There have been numbers tossed back and forth. I talked to my client about this late Friday afternoon. He has seen some figures from Steve Patch, and so have I, but we have to, I would say, clarify a few things before we can send the documents over to Mr. Spiegel and Mr. Bernard. But we have 3 months. I would also indicate, Judge, that this deadline of December 18th was initially proposed by Mr. Spiegel or his client. We did not come up with this number, with this date. We agreed to it, but the initial closing date of December 18th was proposed by them. We have 3 months. We shouldn't even be here today.
Your Honor, may I?
Just a second. I'm looking at this stipulation and order. Mr. Inocencio, when you say you've reached an agreement in principle, that tells me you really haven't reached an agreement. I don't have a signed settlement agreement that all parties have signed. Is that correct?
Correct. What we have is we have letters back and forth between the attorneys saying we will pay X amount of dollars, and your clients are on, for example, Mr. Spiegel's clients have either retired or gone on unemployment. They have arranged for healthcare insurance benefits because they're no longer employed by the company. we will be paying X amount of dollars by December 18th, and everyone is going their separate ways. The only real big issue here, Judge, is how much money, we know the total amount that's being paid. That's not a question. The question really is, how do we allocate the percentages that are going to be paid to everyone? One of the issues that Mr. Spiegel raised in his motion, for example, is how much would be paid to Rick Rogers' sons out of Airway. And I'm paraphrasing, but that was the gist of it. Mr. Rogers' sons have no ownership interest in Airway. So if they are to receive anything out of the Airway interest, it would be out of the goodness of their father's heart to say that they should get some of his 50%. But as soon as our accountant comes back and says, this is the amount allocated to Airway, and we agree on that number, Mr. Rogers will receive, in the settlement agreement, it will be defined as 50% of that number. There's no dispute about the parties' percentages. It's just the allocation of the total amount.
So when you're talking about allocation, you're talking about how much of the total settlement number is allocated to the interest of the defendants, or this one defendant in the corporation, and the interest of the defendants in the LLC?
That's correct. And so
let me finish.
Sure.
We're not talking about allocation of purchase price to goodwill, to assets, or anything like that. I
think we're not looking at that specifically. What we're looking at is Brit LLC, which is an entity that really just owns some real estate. It owns, for example, the building where Airway sits, and it owns some property on McKay over by Industrial Steel Treating, and it has some ownership value there, and there's a parking lot adjacent to that. There's also a piece of property out on Van Horn Road that's effectively hunting land that Rick and Doug own together that Rick is taking out of the equation. And so we're trying to figure out an appropriate value for that. And so what we're looking at is just making certain that based on the party's tax history, Mr. Patch has not been the party's accountant for years, Judge. He's coming into this with a fresh set of eyes. And so he's looking at saying, okay, what has been done historically with the taxes? What assets are out there now? What do we need to do as far as an appropriate allocation? It takes a little bit of time. This company's been around for 50 years. I'm rounding.
But all right, so the agreement in principle that you've referred to, which is an exchange of letters between the attorneys, is it sufficient that the court could enforce that exchange of letters as an agreement? Or are there essential details that aren't mentioned in those letters?
I think the parties do have an agreement based on those letters, except for the allocation. It's just a matter of putting the documents together. So for example, we're going to have resolutions authorizing, that both parties will sign, authorizing the LLC to be conveyed and redeemed, the interest to be redeemed. Same thing for the corporation, things of that nature. But we have an agreement as to Doug Rogers continuing to operate the businesses, and Rick and his sons either becoming unemployed or retiring. We have letters to that effect that Mr. Spiegel and I have shared on multiple occasions via fax. We've also had multiple telephone conversations leading up to those letters that produced those letters. So I think we have an agreement, and Mr. Spiegel's motion reflects that we have an agreement, except for a couple minor issues. And I think if you look at those minor but salient issues, frankly, none of those issues are anything that relate to whether or not we have an agreement. One of the issues he raises, for example, in paragraph 1 of his motion, relates to distribution of accrued pension and profit sharing benefits from Airway to Rick, Ryan, and Brett. Your Honor, that's just a function of having the administrator actually do that at the appropriate time. And that's not we're not saying that won't happen. We have agreed they get their profit sharing. There's no dispute there. So then we talk about the transfer of real estate from Britt to Rick and plaintiff counter defendant Doug Rogers. That's a matter of signing the transfer documents, the deeds. There's no dispute here as to the fact of who gets what assets. And the closing is by December 18th, and the total price is X. And we have an agreement, and it's in writing, that the allocation is to be determined by my client's accountant. There's no dispute about that.
Your Honor.
All right, well, let me stop you. Hold on a minute, Mr. Spiegel. I'm going to give you just a second. There are a couple people in the courtroom that I don't recognize. I want to see why they're here. You folks are logged in as Lauren Acker. What case are you here on?
Your Honor,
Your Honor, if I may, Fred Lucas, these are witnesses for my order to show cause.
Okay, thank you. I just wanted to make sure I wanted to make sure I wasn't ignoring them.
No, sir, they're with me.
Thank you. Go ahead, Mr. Spiegel.
On September 15th, I sent a letter to Mr. Innocencio. I asked for the first and second quarter income statements for Airways and Baker Tilly. I also asked for account statements for Airway Welding's pension and profit sharing plan. And with respect to the allocations, there are substantial salient issues with respect to what is going to be allocated to goodwill, what is going to be allocated to any non-compete, what is going to be allocated to specific assets, what is going to be the form of these deeds. Are they going to be warranty deeds? Is there going to be title insurance? How and when are these deeds going to be entered? When is that going to happen? And with respect to the allocations, we don't need to see the dollar amount of allocations. We need to see a settlement agreement, which has been promised to us over and over again for over a month. And with respect to an agreement in principle, that's just what it is. And finally, nothing. There isn't one word in those agreements, Your Honor, that says that Rick Rogers has retired. He merely stepped away and said that, okay, if I get a settlement agreement, that's fine. But if I don't, I have an absolute right to go back into the company, which he doesn't want to do, but at least have access to the check register, the bank accounts. All this information is necessary for his accountant to be able to determine whether or not those allocations are appropriate. And with respect to Mr. Innocencio's statement that Rick Rogers can give whatever he wants to his two sons, I think that his two sons are not subject to any non-compete because they're not getting any consideration because they have been essentially laid off, even though it's a violation of the temporary preliminary injunction. So I really disagree with Mr. Innocencio, who's had over a month just to get us a draft agreement without the allocations. They are, if he is right, a minor issue. But it's an important issue to get financials so that these allocations, are they rational? If they're not rational, we've got a problem. What is going to be allocated, for example, to goodwill? What is going to be allocated? How is that going to affect Rick Rogers and his tax returns and his tax position?
All right.
May I respond briefly, Judge?
Actually, it's not necessary.
Okay, thank you.
You were here today on a motion for me to empower a receiver to act as a mediator. I'm denying that motion. If you have other motions you want to bring at some future date, bring them on. I'm denying that motion. We're done for today. Gentlemen, have a good day.
Thank you, Your Honor.
Okay, and I believe then that brings us to Sandstone Charter Township versus Morgan. You're Mr. Morgan? You can come forward and have a seat to my left, to your right of the podium. Fred Lucas is here, Shannon, on behalf of the plaintiff, and it looks like he's got a couple of witnesses here.
I do,
Go
Your
ahead
Honor.
with your motion. Your
Thank you,
motion,
Your Honor.
Mr. Lucas.
Fred Lucas appearing on behalf of Charter Township of Sandstone. Your Honor, in this matter, we have filed a complaint seeking injunctive relief against Mr. Morgan for maintaining a travel trailer on a parcel of land located within the township. We have previously had litigation. We had filed a verified complaint, Your Honor, and asked for a preliminary injunction. And this was the date and time set for the order to show cause, which was personally served upon Mr. Morgan. The crux of the matter is, Your Honor, that there is a travel trailer that Mr. Morgan has placed on his property. I have provided to the court some photographs. I don't know if the court received them yesterday. I sent them.
I've seen the photographs.
All right, very good. And those photographs, Your Honor, I could provide, I'll provide testimony from Mr. Powers, who is our enforcement officer, relative to the violation of the township's zoning ordinances by the presence of that travel trailer on a parcel.
I don't think Mr. Morgan disputes that the travel trailer is there. He just doesn't want to have to move it. Am I correct, sir?
Correct.
All right. So I'm not sure we need any testimony.
That's fine,
Since
Your
he's
Honor.
acknowledging that it's there. I was looking at least the portions of the ordinance that you've attached. If I remember correctly, he can't store a travel trailer on this property for more than 30 days without being in violation of the ordinance? Is that accurate?
I believe that's accurate, Your Honor. Bottom line is that as noted in the complaint, Your Honor, in order for him to be able to store a travel trailer on this property at all, it generally speaking has to be kept behind a dwelling or at the side or the back of a dwelling. There is no dwelling on this property.
Wait a minute. I saw something that said behind the setbacks.
Well, it says the parking shall be confined to the side or rear yard of the front yard setbacks. Parking shall be no closer than 10 feet from a property boundary. All off-street parking shall be located on the same lot or parcel as the building or buildings they are intended to serve. There is no there. This.
So if there's no building here, the township's position is you can't park a trailer here, period.
Correct. That's correct, Your Honor. Can't
I'll
use
give
a
you a
residential
chance,
lot
sir.
as a parking, as a site for storing materials and in this case, storing a vehicle, a travel trailer.
Let me, I want to take a close look at the ordinance. It looks like I've only got a portion of it.
I can provide you with any portion that you need, Your Honor. I think I had attached everything that was.
There isn't any question Mr. Morgan is not residing in this trailer, is that correct?
Well, we don't know that. I mean, I have no, we have no information that he is. I've made no allegation that he is.
Yeah, okay. You don't know that he's residing there, and you're not prepared to present testimony today that he's residing there.
That's correct, Your Honor.
Okay. So what we're talking about is the parking of a recreational vehicle in a residential district.
Correct, Your Honor.
And this particular district is it RS1?
Correct, Your Honor.
And RS1 specifically is what?
RS1 is for single family residential. The RS1, it deals with the densities that are permitted, but it is a single-family residential district.
And how large is this parcel?
I can ask Mr. Powers if, I don't
Let
have
me ask
that.
Mr. Morgan. He could, he's right here.
Little over 2 acres.
He says a little over 2 acres. I think I remember reading that. So it's zoned RS1, but we're not talking about a subdivision, correct?
That's correct. It's not, this is not a platted subdivision.
Would this be considered rural property?
Might be considered residential property in a residential district.
But in a rural setting?
Well, all of, there isn't much of Sandstone Township that isn't a rural setting, Your Honor.
Okay. All right, so let me go back to the ordinance. So I noticed that one of the conditional uses in RS1 is open space developments. What exactly is that?
Well, it's an interesting question. Let me pull that up and I'll let you know. And perhaps even it might be faster if I just ask Mr. Powers.
That's fine.
You want to unmute yourself, Ken?
Yeah, I think I would probably have to look that up as well. I would think like a park possibly being developed, something like that.
Your Honor, the bottom line is that open space residential developments are identified. Let me get the open space residential developments. All right. Under Article 7.11.20, an open space residential development is to promote the goals, protect rural character, open space may be permitted. The criteria is parcel contains natural assets, site design. It's basically a residential, it is a form of residential development, Your Honor. That is what that open space is, and it's a conditional use for which I would just add, Mr. Morgan has never applied for any conditional uses for any of this property.
No, I understand there is no approved conditional use. I get that. I'm just trying to figure out if there's any room under the zoning ordinance for him to do that, to apply for a single, an open space development.
Well, that, again, Your Honor, if I may, just to clarify, open space development is basically a means by which you can, I think it would be called a form of, it's designed to relax certain density requirements in order so that if you wanted to preserve more open space in your development, that you could then do that. For example, if there was, I think there's a relaxation on density requirements if you cluster your homes in a smaller area in order to preserve open space. I think that's the goal of open space development. It has nothing to do with this particular use itself. It really has to do with the design of a residential development.
All right, so let's, I want to focus on the parking of a travel trailer. And this is what I recalled reading yesterday. Parking of a recreational vehicle shall be confined to a side or rear yard or behind the front yard setback, no nearer than 10 feet from a property boundary, and then it says a recreational vehicle may be used for the purpose of temporary lodging within residential and agricultural residential districts for a period not to exceed 30 days. So, he's left it there longer than 30 days by your allegation, which would mean he would be in violation of section 10.2.2A2. Now, the distinction you made with the fact of whether or not there's a building there, I want to explore that.
Well, further, Your Honor, it provides that all off-street parking shall be located on the same lot or parcel as the building or buildings they are intended to serve. That's under section 10.2.3. And there is no
But
building.
where does,
That's under the off-street parking provisions.
all right, let me go there.
That's Exhibit D to to the complaint.
So if I understand your argument, Mr. Lucas, 10.2.3, which addresses location of parking, says off-street parking for all uses shall be located on the same lot or parcel as the building or buildings they are intended to serve. Your argument is that this means there must be a building or buildings they are intended to serve.
That's correct.
But that's an argument by implication. There isn't anything in the ordinance that specifically says no off-street parking is allowed unless there is a building or building for which the off-street parking is intended to serve.
I would agree that there is no express statement, but I don't know how else you would read 10.2.3 other than in the manner that I proposed to the court.
Okay, I understand your position fully. Let me hear from, I mean, unless there's something more you want to say, and
No,
I will
I-
give you a chance further.
Read this, obviously. I'm not going to waste the court's time on this in terms of.
Okay, thank you. Mr. Morgan, now it's your turn to be heard.
Basically, they are just telling me that since I don't have a house there, I can't store a trailer there.
Now, this is a trailer that is mobile. You're able
Yes.
to move in and out.
Yes. I got it there, I've got, like I say, there's a little over 2 acres. And I keep my place up. In fact, I've got photos of it, and that's in, 4 years ago was when I bought it, and I bought it because I retired. And I like to spend my time out there to keep the place up. But, I thought, hey, I need a place to relax, have lunch, so I can spend the days there. Family comes, they can visit, and,
You're not,
I didn't plan on it being this much of a problem.
you're not camping out there.
No.
The only
I
time
don't
you
live
use
there. I
it,
live right around the corner here.
you live right around the corner
Around
from,
the corner of Washington and Blackstone.
oh. So,
It's
so-
just, well, when I.
This isn't a-
It's been 15 years and I planned on maybe building a house, I had all the dreams, but the dreams fell through. And I got the trailer, and so when I retired, I thought that would, just a place for me to relax when I'm there. And because I spend time, it takes a lot of time. There's probably 1/3 of it's a pond. There's a sandstone river flows behind it, and
Is
I keep it.
is there anything keeping you from simply taking the trailer there on days when you're at the property
I don't
And-
have anything
and parking it somewhere else?
that's 30 foot.
So you don't have a
I
vehicle
don't have a vehicle
that'll pull it.
No,
So when it gets moved there, somebody has to do that for you.
yes.
Under the most generous interpretation of the zoning ordinance, the longest you could have a recreational vehicle stored there would be 30 days.
Well, as far as the ordinance, I think it's unconstitutional in the first place. I'm paying residential taxes just like everybody else, but they get something that I don't because I can't afford it. That's kind of a discriminatory act, and it's a
Mr.
misuse of the.
Mr.
local government
Mr.
power.
Morgan, if you want to advance a legal theory that the ordinance is unconstitutional, I strongly suggest you hire an attorney. You're probably not equipped to make a constitutional argument. The fact of the
I'm
matter
not.
is, there are lots of cases out there that say that reasonable zoning ordinances are valid and are certainly constitutional.
And I understand this is supposed to be, the township itself is supposed to be like a family, okay? And we have these people that are basically the lawmakers of this, family. And I haven't done anything wrong. Other than put a trailer on my property that I've owned 15 years.
Other than violate the zoning ordinance.
And so, what you're gonna do is deny me, and I have to get a lawyer to to tell you that that basically
The
you're
courts,
supposed to
the court is not going to research legal theories on behalf of litigants. That's what lawyers are for.
the ordinance for the state says you can have a trailer on property if the trailer isn't a junk trailer. That's state, and aren't we supposed to go by the state ordinance if there's a fight between the way this is worded or whatever? Doesn't the state perceive that?
No, sir, they don't. The state doesn't get involved in things like this. I'm charged with following the law, sir, whether I like it or not, whether I think what you're doing is a reasonable use of your land or not, isn't up to me. What's up to me is to apply the law. The law appears to be pretty clear here. Even under the very best interpretation, your trailer's been there longer than 30 days, you're in violation of the ordinance. I have no choice but to grant Mr. Lucas's request for an injunction that compels you to move the trailer from your property, you're gonna have to find a place to store it.
Okay? I won't argue with it, it's just not justice served. There's a
I-
right and there's a wrong. That's, what they're doing to me is wrong.
Sir, I am,
And you own something, and.
I am sympathetic to you, but I have to follow the law. The law is clear. I have to grant this
Well, the
injunction.
Constitution is a supreme law. It seems like that's one you're supposed to follow. And that's against my constitutional rights as a property owner.
If, as I've indicated, you believe I've made an error today, it's certainly,
I can appeal.
you can file an appeal. I would strongly encourage you to hire an attorney for that, because on your own,
You're gonna have to.
it's a very difficult process.
Yes, yes, sir.
Uh,
I just
Mr.
thought it was pretty
Mr.
much cut and dry.
Lucas.
It was dismissed in the last 5 years. It was
Mr.
dismissed.
Lucas, how much time are you willing to give Mr. Morgan to move his trailer before this injunction would allow, would take effect?
And I provided you a proposed order. I sent it
Oh,
over.
you know what? I did see that, give me just a moment. I forgot. I did see that come through. I need to log in first.
I sent you a Word version. You can change it however you think is appropriate.
Mr. Morgan,
Yes, sir.
realistically, how much time do you think it would take you to move your trailer?
Yes, sir. I have to find a place to put it. Can't sell it. Ah. I actually don't know. Not a couple weeks, a month, I have to be in search of to, find.
I'm going to allow you 28 days to get it out of there.
I appreciate that.
And this prohibits you from putting it back.
Okay, yeah, that's what the injunction's about.
If you don't get it moved within 28 days, the township is authorized to move it for you.
Yes, sir. I
So you don't want that to happen, because they can charge you for the cost of removal and storage, and could actually sell the trailer to recoup the cost of having to move it. So I don't think you want that to
Tell you
happen.
the truth, yeah, they can come get it and sell it. I'd let it go. I mean,
Well-
it'd be less of a problem for me.
The problem is, they probably wouldn't,
That's the exact truth, that's like,
They
yeah,
pro-
get it out of there.
they
I'll give it to 'em.
probably wouldn't get for it what you could get for it, and you could still be in the hole. So I don't think you want to leave it to the township to move it. If you don't move it within 28 days, they can do it, but they can come after you and assess your
It's my taxes.
taxes for the,
Yes, sir, I understand that.
all right. With the
amend that order.
modification,
Your Honor, if you'd
I'm
like
sorry,
us
go
to do
ahead.
an amended order for 28 days on it?
oh, I already fixed it.
Okay, great. Thank you.
All right, that's what I'm signing. If you want to wait, sir, I'll get you a copy of that. Mr. Lucas will mail your copy to you.
Thank you, Your Honor.
Peter, would you go pull that off the printer for me, please? Mr. Morgan, I am sorry. I wish I could allow you to keep your trailer there. I have to follow the law, whether I like it or not.
But I thought the Constitution meant something in justice, law, and liberty, and.
I believe in-
What we're all supposed to be living for.
I believe in all those things too, sir.
Are we off record, Your Honor?
Yeah, we're all through.
Thank you.
All right, sure, yeah, just have a seat, and we'll
You
get you a
printed
copy.
it on both sides. I don't know if you
I
meant
hate it when it does that. Print. Must have been the default. Okay.
to. Yeah, I can recycle it.
Twenty-ninth today? Okay, next up is Cervantes versus Smith. You're Mr. Smith? If you could have a seat on this side. And you are Alicia Cervantes. All right.
Your Honor, may I address the court?
Pardon?
If this is in regards to the ex parte motion, correct?
Yes.
So there's not even really a reason to even go forth with it because she's great, and she's a good mom, I have nothing bad to say. It was just kind of we all have our problems in life, so.
So you're okay with me setting aside that?
Correct.
It's
Yes,
private? And that's what you'd like to have happen?
I guess I thought this was for custody.
The ex parte motion, my understanding, is temporarily transferred custody from you to Mr. Smith on a temporary basis. He's asking me to set that aside, which means we go back to whatever the last custody order was.
That's my concern, is because I already filed for custody of Nova, so it just would go right back to that.
Why don't you both have a seat?
Yes, Your Honor.
All right, in my absence, Judge McBain signed an order granting temporary custody of Nova Smith to Mr. Smith. When he did that, he modified an order that previously gave sole custody to you. So when I set this temporary order aside, it goes back to you.
Okay.
That's what you want, isn't it? All right,
So can I address the court and also Mrs. Cervantes?
sure, go ahead.
Okay, so I would like to come up with some type of agreement, because I think she can agree that I'm a good father, and I believe she is a great mother. So my concern and question for the court and request, I guess, would be to enter possibly some type of agreement to where we share joint physical sole custody, and nothing needs to change. We both have her throughout the week. When she wants her, she goes there. When I want her, she comes to me. So there's really no issue with the current arrangement, as long as Ms. Cervantes doesn't have an objection to it or whatnot. So I guess I was wondering if possibly we could do this, if she agrees to it, or if I need to hire an attorney to draw this.
Let me ask her. So apparently, right now, despite what the custody order says, the two of you are sharing custody.
Correct.
Child kind of goes back and forth between both of you. Are you willing for a formal custody order to enter that simply reflects that fact?
My fear and concern is there's been 2 occasions where he has got his family to help to remove Nova and keep Nova from me.
And
So,
I understand
her
that.
being in
I
my
underst-
full custody
I understand that,
is
ma'am,
important.
but that can happen no matter what custody order is in place. If he does something like that and violates a custody order, he's subject to being held in contempt of court. So, but beyond that, I mean, unfortunately, people don't always honor custody agreements. There really isn't anything I can put in an order any more than what it already says. So if an order says the parties shall share physical and legal custody on the following basis, whatever that happens to be, week on, week off, as the parties can agree, whatever. Me putting in the order, neither party shall violate this order, doesn't make it any more effective than if that language isn't there. Neither party is supposed to violate a custody order of the court. Unfortunately, they do it. And when they do it, there's a remedy in place. The remedy is being held in contempt of court for violating the order. You don't have to agree to anything today. And even if we go back to the original custody order, the 2 of you can still agree to do whatever you want. It's just, it won't be in the order. And the problem for you, sir, is if she decides, I don't want to do that anymore, the only way you can fix that is come to court and file a motion to change custody.
See, Your Honor, the thing is I don't really, it's not that, I don't feel Mr. Cervantes would do that, but my only concern is, I mean, to be honest, I've had Nova for a while, and Ms. Cervantes has her 50% of the time given. Anytime she wants her, call me, I'll bring her right to her mom, she can pick up at her mom's. When she wants to bring her home, call me, I'll come back and get her at the drop of a dime. I say I have to work till 6 or something, and then I'll be there at 6, but I'm sure you can ask her, and I'm sure she'll confirm this, that anytime she wants Nova, I bring her.
So that's been working, and I love it when parents can do that, no matter what a custody order says. When the 2 parents come together, they realize, hey, she loves her dad. I want her to be with her dad. I want her to be with me. I want her to be able to enjoy both parents. I want to work as a team to parent this child. I love it when that happens. That's the very best thing that can happen for a child, is when the 2 of you are on the same page. You're working together. You don't care what the custody order says. If you've got something that you need to do, he covers for you. He's got something he needs to do, you cover for him. That's ideal. That is absolutely ideal.
So, Your Honor, can I address Mr. Cervantes?
Sure.
So, if we can just agree to some type of custody arrangement, Alicia, you already know I would never keep Nova, ever.
You did,
But Alicia,
and had your whole family keep it from you in line and give you contact
and
information.
I'm sorry, okay, I'm sorry.
No, you're not, because I asked you if you were sorry, you wouldn't do it again. You did it again.
Alicia, I cannot talk to you, you have a
Sir.
PPO against me.
Okay.
My biggest concern is also whenever she is with him, because he works so many hours, she is not having a routine and laying her head down in the same place every night.
How old is she?
She's a year old. She just turned a year old.
Uh,
I had 2 different times where I'd gone through emotional distress, reached out for help, and it turned against me. When I thought I was putting my daughter's best interests, or my daughter's interests, making sure she's taken care of, I thought that I could trust reaching out to family for support. And instead it was reversed and flipped and turned on me that I wasn't taking care of my daughter. And that's how they want to make it look. But I was making sure she was in a happy environment when I was going through distress, so she wasn't feeling that. And then,
So let me stop you for a minute. You understood you were going through a tough spot.
Yep.
And you said, hey, help me out.
yep,
Can you watch her while I get this solved?
yep,
And then when you did that, he turned around and either got CPS involved or got the court involved to
And
keep you from
guardianship.
taking her back.
Yeah.
All right,
and then on a second occasion,
I'll give you a chance, sir.
on a second occasion, when going through a lot of mental, emotional, physical abuse from Gerald, yes, I had fallen and I given Nova, because he's a great father. Partner, no. Father, yes. So I put Nova in his care, and this was after our anniversary, July 20th. That's when she resided, because he wanted him. She's been there with him for longer, which is not true. And she stayed with him for 2 weeks, 3 weeks, before a big, huge explosion happened between Gerald and I. And then that's when I realized I can't take no more time for me. I just need to take care of Nova. And it was a very situation, not only for myself, but also for Nova. And my concern with the custody is, she is not in the same place. She doesn't have a routine when she stays at this house and she's picked up at 10 o'clock at night and then brought over here to go back to bed, and they're staying at this person's house, this person's house. She's all over the place.
So when she's in Mr. Smith's care, what you're saying is
Everybody else is watching her.
she's not always in his care. She's in the care of family members
Yes,
who are helping out.
might as well be with her mother in her home and where she can have a routine and go to bed.
Okay. So I don't think I can hammer out an agreement today. I would encourage you. I will set aside the ex parte order, and I would encourage you to keep working together. There is a friend of the court hearing to address custody. I'll keep that in place. And you can both go there. The referee will hear from both of you. The referee will try to work something out with both of you. And if they can't, they will make a recommendation for, all right, here's what should happen going forward. And if either of you disagrees with that recommendation, you file an objection, it'll come back in front of me. In the meantime, I would encourage you to keep doing what you're doing.
That's what I would like, Your
Yeah, and it sounds like Mom's willing to do that. So how, if there's a PPO in place, how do the two of you communicate?
Through her mother and through her ex.
I mean, is that working?
I mean,
That's
I don't have a
frustrating.
choice, to be honest with
You
you.
don't-
I cannot contact Ms. Cervantes.
I understand you don't have a choice. Ms. Cervantes, you're saying that that doesn't always work as well as you'd like it to.
No, like it's starting to get, because like I'm using my mother as a mediator, she's in the middle and she, gets
So-
stressed, so it is very frustrating.
So one thing we can do is modify the PPO
Okay,
to allow the two of you to speak without that being a violation of the PPO. Normally, when I have two parents on a PPO, I don't prohibit telephone or text communication. I just prohibit telephone or text harassment.
yeah, that's what my concern was for that, that's why I just figured all ties cut so that I can not,
Well, tell you what, Peter, I want you to go find that PPO file, as long as these folks are here. And let's see if we can't at least fix that today.
Your Honor, I'm sure you've seen it 100 times where people come in here and they have trials and tribulations in life. Okay, I've had plenty of them myself. I'm sure you've seen my record. It wasn't very good at all. Okay, I wasn't a very good person for a long time. I changed. So, you know, I understand that when people go through things in life, trust me, I understand completely. So therefore, I have no objection to all of this, but the only thing that I'm in concern with is, and I'm not saying this would happen because I don't know. I don't know. So my concern is if this ex parte motion is set aside, which I honestly, I really don't have no problem with, but my only concern is first of all, I wake up in the morning with Nova and I'm there with her until at least 11 a.m. And then, yes, she goes to my cousin, which was my aunt and uncle, which is who was gonna have temporary guardianship of her. That's originally what was gonna happen, that's what Mr. Cervantes was referring to. Once everything was worked out, I told him, I said, there's no need for this, and then it was done. We came in here in front of you, and everything was squashed, or dismissed. So, with that being said, yes, sometimes I do work till 6 o'clock, yep, and I have to go pick up Nova, but she doesn't stay other places, Alicia. She stays at my house with me. And I wouldn't do that to her. Nova is my number one concern, not me, not you, not your mom, not nobody. It's about Nova. And you know that. You know that's how I feel. So, I mean.
If those were facts, I would agree, but those aren't facts. I would wait at home for him to come and,
Alicia, that was before all of this though.
but she'd wake up, yeah, he'll be there in the morning, drop her off, and he does not come home, she's sleeping.
But
Picks her
Alicia,
up
that
from
was
people's
when
house
we
when she is
were living
sleeping,
together, though.
interrupts her sleep, and after a while of doing that, when I would have her, she wakes up with night terrors, she doesn't. have a problem with that.
I would agree that a young child needs routine and consistency.
100%.
All right, well, as soon as he finds that PPO file,
Okay.
I will modify that based on your mutual consent so that you can talk to each other.
Okay.
It'll say no harassment though. I don't
Yes,
want this to be a vehicle to harass. Clearly, the two of you have had struggles getting along. I get that. But now you've got a very, very good reason to work very hard to do your very best.
I don't dislike
to
Ms.
co-parent this
Cervantes. If
child.
you ask her, I still make sure everything's okay. I don't need to go into detail, but, you know, I try to make sure there's no struggles for her or my daughter. Because no matter what, whether I'm there or not, Nova's still gonna be at her mom's house. And I do, Alicia,
I fear there's a motive,
there's no motive.
There's
I just want
always
you
a
guys to
motive.
be okay. I don't care about any of that.
but between us, I don't care about us.
I don't.
My
Alicia,
concern
that's
is
fine.
Nova, and you've made it clear that your high priority is working. You enjoy that, and that is your top priority.
Come on,
So
Alicia. Please
If
don't
that
do
is
that.
important, then I will make sure Nova has a routine, a place where she is, you know, having things done on a regular basis, that's building this normalcy, some structure, some stability. And then if you wanna work as many hours as you want, you can, and she's there whenever you're able to see her.
So obviously, we're not gonna be able to come to an agreement on this, Your Honor. So how can we set a temporary order in place, just so that way I get my daughter are we able to do that? Or do I need to hire an attorney to do this? Because this is obviously not gonna work.
There's a hearing scheduled to accomplish that.
Okay. All
I'll
right.
just,
I was just hoping that.
I'll
we'd have to
just
go
make
through that.
sure that it's always good if you can work things out, but if you can't, that's why we have hearings
Yes, sir.
where we listen to both parties, we take testimony, and we decide what's in the best interest of the child. It's always better if you can work it out, and you'll have a chance. I can understand why she's doubtful of your motives, sir, because of the things that have happened. I get it. Trust has to be earned. I think if she continues to see consistency on your part, that will help her to trust that you really do care more about Nova than you care about.
Well, Your Honor, I've had her
Punishing her.
living with me since, at the very latest, early June, and I have verification through
It
my
was after
landlord, all
July.
of my
It
family.
was after July. It was after our
I mean,
anniversary,
we
and I
don't
remember
have to,
saying
I don't wanna
things.
argue, I'm just stating
And then
facts.
that's when we wanted to part, and it was on our anniversary that we officially parted. And then you said you wanted to take a break, and you said at least 2 weeks, and that's when I dropped off Noah. It was even probably a couple days after that. And then I finally realized that you wouldn't leave me alone, you wouldn't stop abusing me, you wouldn't stop anything, like mentally abusing me, that I would finally pack up her bags and drop her off so I could be done and I can get better and I'd be done with you.
See, I don't like going-
Hold on. I don't need to modify this PPO. It already said, it does not prohibit telephone contact. It only prohibits telephone harassment.
Yes, Your Honor.
So I don't even need to fix it. You can call her as long as you don't harass her.
What about arrangements for dropping off Nova? Because that's been kind of a complication.
You can talk about that. You can talk to each other directly. You have each other's phone number?
So if I had to drop her off at his house, is that violating? Or if he had to drop her off at my house, like, I don't want
Oh,
him at my
I
door.
gotcha.
But like, I don't want him at my door, but like, if he pulled into the parking lot to meet up and I dropped her off or something like that, that'd be so much more convenient. Having
All right,
Nova
hold
than
on a
traveling
minute.
around.
That's gonna require that I fix this. Let me,
Should we can just do a 50/50 custody arrangement? I'll pay you child support, whatever you want. I'll give you $200 every week. Just let me have half my daughter. Let me have my daughter half this time. I don't care. Whatever you want. Please.
so what I can do is add a condition in here that allows you to appear at her residence for the purpose of exchanging the child, and allows you to appear at his residence for the purpose of exchanging the child. You can't go inside, but you can appear.
Yes, Your Honor. Thank you.
All right, we will make sure we get that modified PPO entered. That'll happen yet today. You're currently scheduled, I think.
Well, see, when I contacted FOC, I was under assumption that we could come to some type of custody agreement. So the lady said, if you guys can do that, we'll draw it up. You don't even have to submit no.
Absolutely.
And then she also told me when I come in front of you like I am today, to bring it up to you and possibly you could put it in effect.
I can't do it unless you both agree.
Correct, I understand.
She's not willing to agree today.
So can we agree to something, Alicia? Please, you know I'm a good dad, come on.
My biggest concern is, like I said, you, on 2 different occasions,
Alicia, that was in the past.
actually 3 different occasions, taking Nova from me, forced entry, assaulted me, picked Nova up in her high chair and tried to shake her out of it, and threw me across my living room. And denied it, and told the whole family that I assaulted you, and now you have the whole
Alicia, I
family
didn't tell nobody
slandered my
that.
name.
No, nobody slandered your name, and if
You
anybody
did.
says anything, I'll tell them, because they're not gonna do that.
Really? Because you refuse to do that. I love you, but not really.
So, okay, it's not about you and I, all right? I'm sorry for anything that has ever happened. I just want to come up with something, you know, Alicia, please, you don't have to talk.
We have another court date, Judy.
All right, I can't force
understand.
somebody to agree.
Yes, Your Honor, I understand.
But I will make sure that the friend of the court, they're doing a custody investigation. I'm also going to tell them to do a custody evidentiary hearing. If you can agree between now and then, fine. If you can even agree then, hopefully as whatever time passes for them to get you on their schedule. In the meantime, despite what the custody order says, I would encourage you to keep doing what you're doing. I think it's in your daughter's best interest that you're both involved in her life, but I'm not gonna order it. I'm just gonna recommend it.
Yes, Your Honor.
What you're doing seems to be working. Keep doing it. And I think the longer that happens, the greater the likelihood that some trust can be rebuilt between the two of you. I think that'll help. I'm not talking about restoring a relationship.
I like 2 years a lot.
I'm just talking about restoration of some level of trust. That only happens through consistency.
Correct.
Okay. Since there is a PPO in place, ma'am, I want you to leave first. And then in a couple of minutes, once she's gone, you can go.
Do you want me to keep us on the record for the pre-trials, or are you?
They didn't show up.
Oh.
I was just wondering about that. I don't have anybody in the waiting room. I was gonna check with Patty. Could you do that? Ask her if she's heard from either of these, on either of these cases? Because these are attorneys I typically, they have not logged in, so.
Your Honor, off the record, can I?
I can't talk to you off, we are on the record, actually. You can
Can I
take us.
still address the court?
Only if it has to do with the Lions,
How about them Lions?
the Tigers, or the weather. We can't talk about this case.
They broke that,
Have you heard from?
They finally won a game. Finally. What a long, long haul it was.
so my cousin's fiance, he turned 26 the day they won, and that's all he wanted to see was the Lions win, so they actually won on his birthday.
Well, I'm happy for him.
Yes.
Happy for me and all us disappointed